I am Ben Kitilia, the KTN News Center here in Nairobi, and thank you for joining us on the broadcast. It's Thursday night. Kivumbi2017 begins. Right now, we have a lot to talk about. We talk about a change of the election date. That is the date of the repeat presidential election date. We have the details from the Independent Electoral and Boundaries Commission. We also continue with our post-petition analysis following that full judgment by the six judges of the Supreme Court, giving their full judgments, the detailed verdict on how they made the decision on the 1st of September, the four that were part of the majority and the two dissenting voices. We continue to analyze that, and to start us off, we continue with the reactions from both sides of the political divide and from the lawyers. But let's listen in to the President, Uhuru Kenyatta, who has continued to register his displeasure with the way the Supreme Court ruled. He did issue a press statement this evening, continued to say that he does not agree with how the Supreme Court voted, the decision made by the highest court in the land, but he says he is ready for an election and he respects that particular decision.
I take note that the decision confirmed the following. One, that voting, counting, and tallying of the election results was done in accordance to the law. Two, that the number of votes cast, as announced by the IEBC, was never disputed. Three, that the number of votes I, as a candidate, obtained were not contested. And four, that my government and I were exonerated from any irregularities or illegalities. Fellow Kenyans, the presidential election result was nullified on the assumption that there were irregularities in the election result forms. It is now manifestly clear that despite the fact that the relevant forms had already been deposited in court by the IEBC, no proper scrutiny or verification ever took place, which would otherwise have brought the court to the inescapable conclusion that the election results of the August 8th election was indeed valid. As a consequence, I hold our steadfast position that the will of the people of Kenya was subverted by our courts. The Supreme Court owes Kenyans an explanation on how such a monstrous injustice could have taken place.
That is just part of the reactions on that detailed ruling by the Supreme Court of Kenya. And the President Uhuru Kenyatta, just one of the many ways in which he has described that ruling by the Supreme Court judges, especially saying that it was a coup by the four judges sitting, thinking they can make a decision for the rest of the country. Let me now bring in lawyer Ishmael Nyaribo, Jubilee strategist Brian Mbogwa, and political risk analyst Dismas Mokua to dig right into it. And let me start with you, Bwana Wakili. Your reactions to the judgment yesterday, And this reaction by the President, Uhuru Kenyatta.
Yeah, thank you, Mr. Ben, for the opportunity. Number one, I think the Supreme Court judgment has been read, and it is now law. It is actually a precedent we can refer to every now and again. And we can do nothing about it. It has been read. Of course, there can be anger, there can be rage, there can be comments, there can be remarks. You cannot appeal against that except you appeal to the Lord in heaven to probably, assuage your displeasure. But having said that, I also believe that the president at this stage, as the father of the nation, as the president of Kenya, must tone down in terms of the impressions, the emotions he is discharging to the public, to me, who seated somewhere in the village in Kisii. Probably I like him, but when he discharges certain emotions about a decision that has already been rendered, he again puts me off and sends me away. So I believe the judgment is already settled, and now it is upon the country to move forward. And the president, by the way, has a responsibility now to pull the country forward, knowing there is elections coming, knowing that again we will be probably in the same or better situations, so that we should not really linger around telling the justices of the Supreme Court to say, we still expect you to explain beyond what you have written. We want you to come up and explain why you wrote like that. That is not fair. Lastly, Ben, there are 7 judges of the Supreme Court. Once a decision has been written, it belongs to the Supreme Court. It does not belong to 4 guys. It belongs to the Supreme Court of Kenya, and it's our document. So to start to poach or separate 2 or 3 judges and call them something is really not fair. That is a Supreme Court of Kenya judgment, and it now exists in our records.
Brian, do you think the president is lingering on this a bit too long?
I don't think so. I think the president is in his own right to criticize the judgment of the Supreme Court in several bases. Number one, we have this mentality that now the Supreme Court judges are popes or lords. For one time, Maraga said he could not come to the courts on the Sabbath. Whereas I'm a Christian myself, and Jesus himself used to do miracles on the Sabbath day. So I don't see anything wrong with that. Number two is that in the 80s, the U.S. Supreme Court used to rule that slaves were actually properties of their lords. It's only the dissenting judges that made the progress as of to now that slavery was abolished. So we cannot.
What's your point?
We cannot demean the variance of the dissenting judges. Number two is this: there are 2 things that is very critical. Number one, the Supreme Court report from the registrar said one thing. One judge, Joaquin Dungu, said another thing on the same report. So it means one of them must be lying. That's what the president is saying. Even if we can do nothing apart from Lord in heaven, as my friend has said, but we can review the judgment. Our mind cannot stop thinking.
Right.
So whatever was put in place, the reason why they preserve the evidence is for such things like review. The judgment can be reviewed. We'll see how did they arrive at this ruling.
What is your take on the judgments from
it was underwhelming.
The majority?
It was underwhelming. In fact, myself, NASA guys were expecting IBC to be indicted so that they can continue with their irreducible minimums. But right now, the judgment was underwhelming. They say there was irregularities. They say there were illegalities. On the part of illegalities, the Chief Justice dismissed everything, that there was no evidence. So according to the ruling that he read, there were no illegalities. Irregularities, they are administrative. Like Form D is supposed to look like this, Form A is supposed to look like this, but they did not question the content, which is the result. The result is the content of the form, not the form. They did not question that agent of candidate A, say polling station A, we got 100 votes. This one is saying 96. They did not question that.
We'll get into what exactly are the main pointers of this judgment. Do you agree with Brian that judgment was underwhelming?
Well, when Brian says that the judgment was underwhelming, it depends on the parameters he's using. For me, I sat and I listened to the entire judgment, the majority view as well as the dissenting view. But there are so many things which we need to look at, Mr. Kitili, so that we are able to make progress. It's important for everybody to make a view, a suggestion on the judgments. And that's allowed all over the world, in the Commonwealth, in the US. People should attack the judgment vigorously. They should attack the rulings. They should attack the determinations and everything vigorously without attacking their personalities. Because as Mr. Nyeriba has indicated, these are Supreme Court decisions. It was made by 6 judges. And it's no longer a personal property. It's become law. So we should attack it vigorously, but avoid attacking personalities and dragging people's reputation in the process. That's number one. Number two, it's unlikely that the Supreme Court would have come to a conclusion and name maybe a number of commissioners and a number of managers as guilty of electoral offenses, because, you know, those are criminal charges. Now, in the unlikely event that they would have made that blanket condemnation that IBC has committed a number of offenses, then it would have been very tricky for the lower courts. Maybe these are criminal offenses which are supposed to be tried, say, at the magistrates' courts or the high courts or even the courts of appeal. Now, the moment the Supreme Court makes a determination that a particular person is guilty, and, you know, maybe they could point at a wrong direction, then it compromises. The magistrate would be in trouble to try and give those people a fair hearing. But they said there were systematic failures within IBC. And then they indicated that the system at IBC was infiltrated and it was compromised. Now there are independent organizations like the Directorate of Public Prosecutions. They would now have the opportunity to go, based on the fact that they've been advised there were illegalities, irregularities, the system was infiltrated, the system was compromised, then now they would, Mr. Keriako Tobiko would have the opportunity of going to IBC and proceeding with his investigations. And this is something that he needs to do on his own motion. In my understanding, and I've attempted to read a bit of law, the Supreme Court was just supposed to offer a global view, and then the relevant agencies go and fish out the details. And believe you me, the Supreme Court, those judges who wrote the majority, if you have a conversation with them, they would easily point fingers. But they do not want to start limiting and pointing the lower courts in a particular direction. That's number one. Number two, President Kenyatta sits in a very precarious position. He's a presidential candidate and he's the head of state. So people expect him that when he's issuing a statement, which is as powerful as the Supreme Court judgment, that he needs to do it in a restrained manner, in a structured manner.
Right,
because everybody in Kenya looks at President Kenyatta as number one, before he's a Jubilee candidate, as a symbol of national unity. When the nation is in trouble, we look at him and he gives us some sort of aspiration. Right. When he loses his cool, yes, then all of us get worried.
Fair point. I'll come to you, Brian, for that. But let's listen into what President Uhuru Kenyatta had to say earlier this evening. He did indicate that Jubilee were indeed ready for that repeat presidential election.
The court ordered the IEBC to conduct a fresh election in strict conformity with our Constitution and the applicable election laws, and to do so within the 60 days that the Constitution allows. We all acknowledge that the people of Kenya now have another chance to be heard again. There shall and must be an election within that constitutionally stipulated period. Cabinet this morning approved a supplementary budget that shall be forwarded to the National Assembly on Tuesday of next week, in which we set aside resources for the conduct of this fresh.
Cabinet has approved a 10 billion shillings supplementary budget for the repeat presidential election. Gentlemen, the president is saying that indeed Jubilee are ready for the election. Brian.
Yes, Jubilee has always been ready for election. And what I heard yesterday for Rengo saying it was mischievous, claiming that we'll have a caretaker government, Marangas will be in charge. You know, invoking the name of the CJ at that juncture, it it was wrong because the Constitution has expressly stated, with the absence of the President, whose take over, the Speaker of the National Assembly is before the Chief Justice, and the express provision of the Constitution says the President term lasts from the time the President is sworn in until the next President is sworn in. So there is no point of saying there will be a vacuum, whereas we have an express provision of the Constitution and try to bring in imagination that the Constitution did not envision after 60 days this. We have an express position. So the other one is the imagination.
Brian,
that's number one.
Pundits are asking, as you continue making your points, if Jubilee is ready for the election, then why do you still why are you still lingering on this issue of the judgment and wanting to analyze it, saying this was wrong and this?
Yeah, the reason is nobody challenged the content of the results of the election. Nobody challenged the numbers. And the judges says numbers do not matter. That's the biggest problem with Jubilee. Where again, if numbers do not matter, why are we going next to election? Number one. And number two, this ruling is mischievous.
The Supreme Court said the election is more than just numbers.
Yes. To me, I tend to disagree with them, and I side with the two judges, irrespective of what... my brain cannot stop thinking just because other judges say this and this. Because even the four, they are not popes. They can be wrong.
True.
They can be wrong. The two can be right. And the reason why dissenting judges give their opinion is so that it can also try and cure, it's like an appeal in itself, because it's dissenting from the majority saying you could have looked at the law in this other way or in this other way. So it will also help the lower courts not to make the same mistake that the four judges did.
All right. Ishmael?
I think I agree with Brian when he says that, Honorable James Orengo, was referring to who's to be president outside the parameters of the law. On this one, I agree that people should practice restraint. In fact, both NASA and Jubilee should by now agree on a formula of conducting an elections within the limits of law without having to steal a match. This one, I agree. And therefore, the president and the leader, the Honorable former Prime Minister, Honorable Raila Odinga, should actually, in one way or the other, agree that, you know what, we must move the country forward. We are going to contest for the elections again. Can we agree? The biggest problem we have, Ben, is the IEBC is just coming one evening and saying, hey, we want to do the elections on 17th. We had, I can see on media, there were about 26 remaining. Now there are 34. And this is what Honorable Raila Odinga kept saying. Do not just ambush anyone. Let's make sure that the field is leveled and everybody is ready. So lastly, when my brother says that the Supreme Court has made a judgment and therefore we should continue making remarks about it. And again, I agree. We must criticize and critique the Supreme Court judgment. But on this point, for example, he's saying that no one was found culpable. Remember, in the ruling, it says that we cannot find the footprints. And again, he said that the numbers don't matter. Jameni, let's not pick just elements of the ruling or what was just spoken on media.
All right.
In fact, numbers matter. And that's what the judges have found out. Though indeed, they say that for them to really matter, you must look at the process.
Indeed, we're coming back. Just hold that thought. We're coming back to discuss more about the pointers, the key pointers of that ruling, and see what the Supreme Court really said. I just wanted us to take a look at President Uhuru Kenyatta's reaction to that ruling by the Supreme Court. I want us to shift gears a bit to the issue of the election date change. And of course, as you can see at the bottom end of your screen, it is now 34 days to the election. The Independent Electoral and Boundaries Commission has changed that date for the repeat presidential election from October 17th to October 26th. In a statement to the media earlier this afternoon, the IEBC chairman Wafula Chebukati did say that, give reasons for changing that date, saying they want to ensure the commission is fully prepared to deliver an election that meets the standards as set out by the Supreme Court of Kenya. IEBC Chairman Ofole Jabokati says they are continuing to review the detailed judgment by the 6 judges of the highest court in the land, and saying tomorrow, Friday, they will be issuing a more detailed statement of preparedness by the IEBC for that repeat presidential election. Right, so let's switch gears to that. We'll come back to the judgment again. Let me start with you, Dismas. Is this the right decision by the IEBC to change the election from 17th to 26th? Not a big difference, really, but what does this mean?
Well, I wouldn't be worried about the dates, whether it's 17th or on the 26th. But what I would be worried is whether or not IBC has done sufficient stakeholder consultation. Because the elections are supposed to be held in a manner which is very structured, which is very transparent, accountable, and all the key players are supposed to be happy with it. One would have expected that Mr. Chebukati and Mr. Chiloba would have held consultations with the presidential candidates for Jubilee, with the presidential candidates for NASA, and other interested parties, the observers, the religious sector, with the private sector, so that together they properly sit down and understand what the Supreme Court's determinations were and the judgments. Then they do a quick special audit of the challenges that IBC is facing, so that you have a bipartisan support for this election. Now, when you come up and you say this is when you're going to do the election, and there's no evidence that you've held consultations with especially the 2 key players, that's President Kenyatta and Raila Odinga, so that these things are acceptable by all the stakeholders. There's a very high probability that one of the players again would say, since I was not consulted, I'm not going with it. Or we have not identified the challenges that have brought us here.
But to be fair to the Commission, they have been trying to call meetings which both sides of the political divide have been, avoiding.
But you know, Ben, at this stage, when you sit at IBC in a very precarious position, when you're calling those meetings, the meetings must be called in a structured manner. You do not just wake up in the middle of the night and say, tomorrow I'm going to have a meeting, and then you call the candidates or the interested parties without a very solid agenda. It must be very structured. But be that as it may, right now what we need from IBC is to be told the failures as identified by the Supreme Court. What are these illegalities? What are these irregularities, and how do we cure them?
Right.
If it's the issue of the KIMS technology, how do you sort it out? If there is the issue of Al Ghurair, how do you sort it out? If it's the issue of personnel, how do you sort it out? Because the Supreme Court in its ruling said yesterday that if you repeat these mistakes and you come back to us, we'll still arrive at the similar decision. Now, there's a very high risk that if IBC doesn't do things the right way, we'll be having elections every 60 days till 2022, because the Supreme Court will be sitting and they'll be annulling an election every now and again. And I wonder, as a nation, why our public servants do not do the right thing. IBC knows the right thing they're supposed to be doing.
Right.
If Jubilee has raised concerns, why can't IBC sit down and sort out the Jubilee concerns? But at this stage, majority of the concerns are coming from NASA. Why can't they sit down and maybe come up with a national delegates, stakeholder conference, right, invite all the key players and iron out the issues? Because what Kenyans are interested in is going for an election. And it doesn't matter who's going to win, whether it's a President Kenyatta, whether it's going to be President, or rather Raila Odinga. Anybody who wins is supposed to be sworn in.
Right.
And when IBC makes a declaration that it's Raila Odinga or it's President Kenyatta who has won, all key players will go home knowing that, in fact, the person who has been declared a winner is a winner. At this stage, you cannot afford to start, flexing your muscles, saying that I'm the chairman, I'm not going to consult, or I'm a presidential candidate, I'm not going to participate in a meeting. Kenyans want a free, fair election, because now we are fed up with the tension in the country. People are nervous.
Brian, we have the full judgment is here with us. We have a new election date, but NASA insists they are sticking to the hardline positions of the reforms they want at IBC. Do you agree with those changes that need to be there, according to NASA?
They are just being obtuse. Election is supposed to be done in 60 days. Whatever I understand about reforms, it's much bigger than these administrative things. Just saying from 34A, from 34B should be this, that's not reforms. Reform go deeper into the law guiding the election, and it cannot be done within that period. And they know that. In fact, what I know, NASA do not want elections. Number 2 is this. IBC, the Supreme Court ruling left IBC out of the hook. They were not specific. And you know, that's the problem with this ruling that I'm seeing. Because when they gave a summary ruling on the first, they said there were irregularities, illegalities, and they did not pinpoint exactly what IBC need to be done. You know, in the past dates, election used to be free and fair. We did not have these things of verifiable, transparent. It used to be clean and free and fair. And for now, the court ruled that election was free and fair, but they were not verifiable, which to me, it's a big problem in this sense. In this sense,
yes.
You see, you are telling IBC to conduct election. IBC was guided by the Kiai ruling that the constituency tallying is final. From my understanding of the word final, even in dictionary, it's final. You cannot review the final thing that has been declared by the returning officer at the constituency. So telling Chebukati...
But it has to be verified.
Listen, by who? By the RO. Because whatever you're being brought is final by the RO of the constituency. That was the problem with that was the problem with that law. In this sense, Chebukati, to his understanding of the law, and even Orengo and company went to seek the guidance of the interpretation of the same law by the Court of Appeal, say that the constituency is final. And they told Chebukati, why don't you trust your employees? This man was there telling that those people were employees of Chebukati. Why don't you trust them? Now, why do Chebukati need to look at Form 34As and he's been given Form 34Bs?
All right. Let's hear from a legal perspective.
Yeah, that is the law.
Is that in order?
Yes. That is the law.
Yes.
The law says when you vote, the polling clerk, the polling presiding officer, is supposed to send electronically that Form 34A to the RO in the constituency, and simultaneously is supposed to send it to the National Tallying Center. Do we have any query about that? No, we like the law. Now, what my brother is saying, and which is true, that is the law, that the RO makes or generates the Form 34B, and his or her work is actually final. The question before the courts is not that. The question is, was it done that way as ordered by law or not? No. And what the judges are finding is, whereas we gave authority to the returning officer to generate Form 34B, either she or he did not generate, or the generation did not tally with what was sent from the constituency.
All right, please.
That is what the constituency is.
One minute before
hold that thought. Let's take a quick commercial break here on Kivumbi2017. When we return, we will come back to this issue of the detailed judgment by the 6 judges of the Apex Court in Kenya. Of course, as we've told you, there is a new election date. 26th of October 2017 is a new date for the repeat presidential election. It is 34 days to voting day here in Kenya.